koutou katoa, no mai, haere mai. Greetings everyone. Welcome to our latest NZFreeLaw Podcast, brought to you by ture.co.nz. The purpose of the podcast is to assist with fulfilling Ture's mission, which is to connect New Zealanders with better access to and knowledge of legal services. So NZFreeLaw talks all things law in New Zealand. My name's Julia Stenson. I'm the founder of ture.co.nz and this podcast, NZFreeLaw. Now, today I'm at the office of Stephanie Ambler, who is a family lawyer based in Hamilton. Welcome to the show, Stephanie.
Thank you, welcome.
And thanks very much for letting me talk to you today. Do you want to just tell us a little bit about yourself so listeners know?
Sure. So I am a family lawyer. I live in Cambridge, which is a beautiful part of the world. Yes, I have two lovely children, aged 13 and 10, and I'm married to Stephen, who is a detective sergeant for the New Zealand Police.
Oh, wow, that must be an interesting job.
It's a great job in terms of we're both people-focused.
Yeah.
So we both wanted to be in a profession where we're meeting people on a daily basis. We're former Aucklanders, relocated 6 years ago.
Reformed.
We are. We now call ourselves as being from the Waikato. We've set down roots here, and the move was made for the interests of our children to provide them with affordable housing and great schools. And it's also a great place to work.
And you found it to live up to your expectations?
Absolutely.
Yeah.
Surpassed our expectations. We're really enjoying it.
Great, great. You know, normally I have a co-host with me, Josh. When I first started doing these shows, Josh said, why would you talk about... He just couldn't understand the idea that people get into law for people, to help people. He thought it was about the law. And so when you say, you know, my husband and I got into this work so that we could deal with people, it was really... Every time we have a show, every lawyer says the same thing, that it's about people. That's what I'm talking about. The next part of the show we talk about is called the legal word of the day. I usually don't let on what that's going to be, but don't worry, I give a bit of a definition. So today the legal word is a couple of words that we're going to unpack. The first is separate property, as opposed to relationship property in the context of family law. So my understanding is relationship property is property that's been used for family purposes, such as like a house or the furniture or a family car and things that have been acquired together during the relationship. Whereas separate property may be informally defined, I'm informally defining it, as property that, of course, is not relationship property that we just talked about, but rather that it's an individual may have obtained when they weren't together as a couple. So as a general rule, if I come into a relationship with an investment that I've put money into, like some kind of shares that I might own, that I might have purchased, then that will be my property and will continue to be my separate property. But it can get blurred is where I really want your input here, Stephanie. Well, number one, does that sound right? And number two, I imagine it does get blurred when separate property can become relationship property.
Yes, so the basic parameters of what you've discussed are pretty much correct, but obviously the Property Relationships Act deals with two key pieces of property, one being relationship property and one being separate property. And they're both defined in the legislation. So you're right in that relationship property deals with assets such as the family home, the household chattels, your motor vehicles, your income that you earn from salary and employment, and also your KiwiSaver or any superannuation contributions that you make during the relationship.
That one's probably got to catch people, the KiwiSaver.
Yeah, it does. And some people are just unaware that those types of assets fall within becoming part of the joint pool. Separate property is generally assets that people bring to a relationship. So you're right, if you bring an investment, some shares that you had prior to a relationship, then that will be separate property at law. But if you bring, for example, a house to the relationship, so you own that and you bought it prior to the relationship, it can lose its classification as separate property once you've been living together for 3 years, because that's an asset that's got significance to the family. It's your family residence.
Yeah.
So it becomes relationship property and subject to equal division after 3 years. There's also assets that can be separate property but be acquired while you're together. And for example, that's an inheritance that you might receive from a family member. So say, for example, if a parent dies and you're gifted under their will $100,000, that's your separate property at law. But the catch is it depends what you do with it. Right. So some people decide to put that onto the mortgage and repay debt towards a joint family home. Those sorts of activities are going to mean that you're going to lose your status of your separate property asset. So if you're contributing your separate property to a joint asset, that's at risk of losing it. So if you want to preserve it as separate, you've got to keep it separate. So tucked away in a bank account in your personal name, you'll preserve it as separate.
Wow, okay. Just a tricky scenario as well that I conjured up that I'd like to get your educated view on is, so let's say somebody has a family trust, so they're in it with other members of their family, say their mum and their brother, for example. They get married, and then down the track, let's say 3 years, just to remove that argument, they separate. Now, in that family trust, there was a house that was owned. It's rented out for income purposes. But the family, let's say it was me and my husband, went and we have a child and we go there for holidays maybe once a year. And then down the track 10 years later, it goes to be sold and we're getting divorced. Is that separate property? Let's say that maybe I've been contributing something out of my income towards that if I need to, say the rates or something.
Yeah, so trust properties are a really murky area of our law at the moment. So in terms of the Property Relationships Act, there's really limited provisions dealing with trust property in that piece of legislation. What it says is if relationship property is transferred to a trust during the course of a relationship, then the non-owner spouse can get some sort of compensation if they've lost an interest. But the remedies are pretty limited. It's got to be relationship property in the first instance going into the trust. So on that scenario, the property was owned prior to the relationship, then no, it wouldn't actually fall within that provisions of compensation.
What if it was bought after, then obviously that's where it gets a bit grey.
If it was, that's right. If it's relationship property that went in, then yes, it could be vulnerable to a claim. But trusts are so common in New Zealand these days. So there is a whole body of case law that's been built up in the family law context about claims to assets and trusts. So one of the key pieces of legislation is called the Family Proceedings Act, and that's become quite popular and known as the trust busting provision because it enables the family court to make assets against trustees. And really, just to qualify for a remedy under that, there has to be a settlement on a trust while you're together.
Right.
And there has to be an expectation by a spouse that they'll receive an interest in that asset. Now, one loophole in our legislation is that that section only applies to married couples. So although the Property Relationships Act applies to both defectors and married couples, the Family Proceedings Act currently only applies if you're married. But in terms of the Law Commission's recommendations that are before Parliament at the moment, that's going to be tidied up, hopefully.
And so it might be broadened to other types of relationships.
To extend, that's right, to extend to de facto couples as well. And then otherwise, what de factos have to do at the moment is make a claim in equity for constructive trust to say that they've made contributions to a trust asset, which is where, in your scenario, if you say, well, I've paid money of mine to an asset, well, that could be deemed a contribution to the trust asset. But again, you've got to prove that you had an expectation that as a result of those contributions you were making, you were going to have an interest in that asset.
Right, okay, which kind of is similar to how it might be handled with a will when they're looking at expectations in that respect of if there was, although with a will, the difference, I guess, is that it has to be kind of agreed up front that that's the expectation rather than just in somebody's head that there's an expectation, if I do this, then I will get this asset.
Yeah, that's right. Under the Law Reform Testamentary Promises Act, you've got to have those contributions being made, but also there's got to be a promise in there somewhere that you're going to be receiving that asset on death.
That's an interesting one to kind of, because it's quite a specific and significant difference in the law around similar assets, but just for family versus somebody passing away.
Yeah, that's right. And obviously with that piece of legislation, the Law Reform Testamentary Promises Act, it can apply to complete strangers in terms of provided they can meet the service they've provided or the contributions and can prove that promise. You could have a stranger making a claim on someone's will, which
is a bit scary, really. A brief overview can you give us of the kinds of matters that you handle on a regular basis?
Sure. So family law is quite a broad area of law. So we cover a wide range of topics. So the one that normally springs to mind for people is separations. And probably about 90% of my work involves separated couples. And with that comes a number of issues arising from it. So one's the care arrangements for their children. So you're living in separate homes. Whose care are the children going to be in? How often are they going to have contact with the other parent? Another issue is obviously the division of property that arises from a separation. The third issue is support payments for children, payment of child support. And then finally, whether or not a spouse or partner qualifies for spousal support. So that's in circumstances where the wife, for example, has stayed at home caring for the children and upon separation can't meet her own needs. So that's a little cluster of issues in respect of dealing with separations. We also deal with the transactional commercial side of property arrangements, usually before someone commences a relationship. And they're often known as prenuptial agreements, contracting out agreements, or relationship property agreements. So that's people who generally come to a relationship with an uneven platform in terms of the assets they own. So we help people prepare their agreements and whether or not they want to contract under the legislation. We also help with claims upon death. So there's claims under the Family Protection Act, so that's claims by family members to the estate assets, and also the claims under the Law Reform Testamentary Promises Act as well. We also deal with assisting elderly or incapacitated people who are unable to make decisions concerning their health and welfare and also their property management as well. And those are cases where there's no enduring powers of attorney put in place during a lifetime. Someone loses capacity and we need to apply to the family court to have a person put in charge of a family member's health and welfare and their property.
You've touched on something that's probably quite useful to unpack a little bit more, which is enduring powers of attorney. It sounds like a big set of words, but it basically means that someone else is put in charge of somebody who is in a vulnerable or incapacitated state to look after their affairs. And so it obviously is an important position in terms of trust.
Absolutely. So there's the two different powers of attorney. So there's the one concerning personal health and welfare. So that's what medical treatment someone should be receiving, right down to whether or not a life support machine should be turned off. So really important personal decisions, and one person can have that role. So some thought needs to be given to who's that
quite a pressured
person.
Role.
Absolutely. And then in terms of the property, you can appoint a couple of people to manage your property assets. And again, that's really important. It's quite a simple document legally to put in place. And if you don't have one, then the ramifications are quite large in terms of we need to apply to the court to get property orders. That requires an application, an affidavit, medical evidence that the person's lost their capacity and can't make their own decisions. Those documents then need to be served on all family members. There can be a dispute about who that role should be given to. And the costs can be quite significant, particularly if you've got a defended application. So it's really important for people to, what I say, go and get your health check from your lawyer and just sit down and talk to them about your will, about your powers of attorney, and making sure you put those in place.
Yeah, and I think a lot of people don't understand what that means and don't really understand the gravity of, particularly if you're asked to be that person, to take on that role as well. It's just as important. So it's important for the person who's appointing somebody, but it's also really important to understand the pressure from the medical side, but also the property side. That's a big ask of people.
It is. And in some situations, in terms of the property, some people may appoint, you know, like a corporate, like the public trust or the guardian trust, to manage their affairs, because they don't want to give that role to a particular family member. So there are organisations out there who will step in and manage people's assets, but that personal care and welfare can only be given to an individual. And while some people may appoint their doctor, it really, given the significance of those decisions that are being made, it should really go to someone who knows the person, who knows whether or not they want to have certain medical treatment undertaken or not.
That's quite a lot of work that you cover then, isn't it?
And I haven't, I mean, there's other areas too, one of which are quite rare in New Zealand, but we do them, and that's adoptions, which are really special.
Right.
Because it's the one and only time that children get to go along to the family court, which is lovely, and to have them welcomed into the home, and also surrogacy agreements too. So it is a very broad-ranging area, but it's fantastic in terms of the contact with people that you have on a daily basis.
Definitely. Okay, so we talked about the difference between separate property and relationship property and how it can be a bit messy. Can you just give us an overview of what a couple can do? I know we sort of touched on it in terms of the types of matters, but just kind of unpack it a bit more around the start of a relationship. When a couple feel that they've been together, let's say 2.5 years, they know that it's coming up to 3, and where do they stand with what they own? For example, what should they do, you know, if they're going to move in together and start sharing assets?
So it's really important for people to go and see a lawyer to get that advice around, have they got any separate property assets that they need to keep separate?
Identifying them.
Absolutely. Just having that knowledge and understanding. Do we even need an agreement?
Right.
Because some people might come to a relationship with separate property but still not need an agreement because the law is going to keep it separate.
Right.
So where we usually have a relationship property agreement or a contracting out agreement is where you get a couple where you have one partner that has significantly more assets than the other. For example, they've already got a home and the parties are deciding to move in together in that home. And in circumstances where that home has got significant equity, then it's not unusual for the person, the homeowner, to want to preserve that equity as their separate property.
And the other person just brings their cat.
Well, a cat's an asset under the Property Relationships Act too, so they might want to put their cat in their schedule of assets that they want to keep as separate property going forward. That's usually the situation where they want to have a contracting out agreement. Another one is where parents, for example, make a gift or a loan to the couple to purchase their first home. Because as we know, property prices are
common,
pretty expensive, and people are reliant on their parents to make that contribution. Many parents are only willing to make that contribution if there's a relationship property agreement in place. So that would simply say, if this couple separates, the parents will get back what they put in. So often we say to people, a relationship property agreement's like an insurance policy. You may never need it. You may never need to get it out of the drawer. But if you separate, you've got it there protecting your assets.
And the old saying, everything's fine until it's not.
Absolutely.
It is like insurance. That's a really good analogy. That gives listeners a really good idea around what they should be thinking about and the sort of situations that if they feel they've got a lot of assets, that maybe they should get that insurance in writing in the sense of having it down who owns what. So let's move from that situation where you start a relationship where it's working but you want to have a clear understanding to the unfortunate but very common instance where further down the track there's a breakdown in the relationship and it comes to an end. But before we get to that, I think let's just talk about what's covered in the sense of which couples. If you're married versus you're not married, you've been together 3 years or you haven't been together 3 years, you're married but you've only been together 1 year and it falls apart. So if we just talk about the different sort of circumstances that the Property Relationship Act covers.
So in 2002, they amended our legislation to provide for de facto couples. So what we have now is that the legislation will apply to de factos who have been in a relationship for 3 years. So that's where it can get murky, because although the legislation has a definition of what a de facto couple is, there's lots of arguments about whether they are de factos for 3 years or whether they're not. So I recently had a case in waiting for a decision on it in terms of one client saying we've been together for 18 months and the other saying we've been together for 3 years and 3 months. So the consequences of being in that 3-year relationship can be pretty significant financially, particularly if there's a home involved that could be divided in half.
Yeah.
So it does apply for de factos who've been living together as a couple for 3 years. The court has got the ability under the legislation to make orders if it's less than 3 years, if the couple have a child together.
Right.
And failure to make an order would result in a significant injustice to the other party. So there's some discretion there to produce a fair result. But in terms of married couples, the time starts running from the de facto date or the marriage, whichever is earlier. So if you move in together, say in February, and you marry 6 months later down the track, we're going to start from the de facto date. That's when the relationship starts running. If you're together as a married couple, less than 3 years, you are within the legislation automatically, but it's not an automatic 50% split. They're called marriages of short duration, and the court will divide the assets unequally in accordance with the contributions you've made to the marriage.
Okay.
So there are different rules around sharing. There is a difference if you're married or de factos. So again, it's just
not clean cut.
Being aware.
But the general rule is, short de facto. If you're coming up to 3 years, that's when you maybe start thinking about visiting a lawyer to talk about what is separate property and what will be relationship property.
Often we say don't leave it till coming up to 3 years.
Right.
Get in before you start living with someone is really important, because the rights start running as soon as you live together. So we say to people, get in before you're living together and get your agreement done. Or if you leave it, you can probably leave it for about 1.5 years, but start negotiating it, because agreements are only binding if they've got independent legal advice. So each party needs to have a lawyer. One might draft it and then the other lawyer says, I think it's unfair and you shouldn't sign it. And there's some toing and froing between the lawyers.
And I would imagine the longer you leave it, the more awkward it gets.
Absolutely. And the longer you leave it, the more risk there is that it could be set aside in the future. And it's not uncommon. You see some agreements, they used to be the case. You'd see agreements being signed on the Friday before the couple married on the Sunday. And in circumstances where agreements can be set aside if they result in a serious injustice, one of the factors the court looks at with serious injustice is, was it unreasonable at the time it was made? And if some people are being pressured into signing an agreement 2 days before they're getting married, don't really understand the consequences of what they're signing, but don't want to call the wedding off, they can be unreasonable.
Right.
So it's important not to leave it.
Yes,
to the
very
last
important.
Minute. Yeah.
Okay. It did kind of circle back to making sure you were prepared at the start of the relationship and not leaving it too late. I think a lot of people leave it from a psychological point of view. People leave it because they don't want to upset their partner. It's a new relationship. They don't really know where it's going, and they think, well, let's just see where it's going in case before we jump the gun and say sign here on the dotted line. But, it can really make a huge difference down the track if you've dotted your I's and crossed your T's, is really what I'm hearing.
Yeah, that's exactly right. You want to make sure that you've had your advice, you've got your agreement lined up. And what people need to be aware of is it's like a will and it's like your insurance. It can be updated. So an agreement might be fine at the commencement of a relationship, but 5 years down the track, you might want to get it out again, have a look at it, see what it says.
Right.
And it might need updating, or there might need to be some variations to it. So you can just update it, amend it. Again, it needs to be signed off by independent lawyers, but you can change the provisions of it as your circumstances change.
I'd never actually thought about that, but that makes perfect sense. You have to get it reviewed on a regular basis. Let's move now into the instance where there is a breakdown in the relationship and it comes to an end. So what can a person who's recently separated from their partner do, Stephanie, in terms of the legal kind of process around children and property?
Okay, so there's generally two parts. One I call to deal with interim issues and one with substantive issues. So the interim issues are the ones you want to deal with pretty quickly. So in circumstances of a separation, it depends who you're acting for. Are you acting for the financially secure couple or are you acting for a couple who may not be employed, may not have any income of their own? It's really important to get those interim financial arrangements in place quite quickly. So does someone need spousal support? Do they need income from the other party after they've separated? How are the children's expenses going to be met? How is the mortgage going to be paid? Who's going to stay living in the family home? So they're what I call the interim issues, and they need to be dealt with pretty urgently to make sure the parties are secure. Then we've got the substantive arrangements, which is the division of your relationship property, separate property.
Arrangements.
That's exactly right. And that process can take some time. So it's really important in New Zealand we have full disclosure of all assets and interests. And the solicitor signing a separation agreement has got a pretty big responsibility. They need to sign a certificate that says before they've signed the agreement, they have explained to their client the effects and implications of the agreement in accordance with the law. So some people say, well, how much is it going to cost me? Are lawyers out to make money on this? No, and we always say to people, try and, if you've got an amicable relationship with your spouse, keep it amicable because it's going to be much more cost effective to do it that way. You can certainly sit down with your spouse and reach an agreement on the value of the home, who's going to keep it, what assets are going to be sold. The lawyer's job is to gather all the information about the assets they've got, to understand what value the assets have and whether or not the split is an equal division under New Zealand law. So that's really important. Right. People might want to, say a husband might want to give his wife more than 50% of the property. They can do that. It's just having an understanding about what is an equal division.
And so each needs their own separate lawyer to give independent advice?
That's exactly right. And that's really important so that both parties' interests are represented. People know what they're giving up, so to speak, or whether or not the division from their perspective is fair.
And you see in a lot of these sort of Hollywood things around breakups that there's all the suspicion around one partner hiding some assets somewhere in a foreign account or something like that. So it must be quite a big responsibility for the lawyer to make sure that they are across all of the assets and they are being transparent about that to the other party.
Yeah, and we still get those sorts of cases, to be honest. You know, there are cases where we do have to go to court and apply for discovery orders to get certain documents. Okay. And in some situations, we actually have to apply for third-party discovery orders. Now, what that means is that the husband, I've said the husband, that could be the wife, says, I don't have those documents. They're not in my possession or control. So in some cases, and they are rare, but we might have to seek a discovery order against a bank.
Yeah, right.
To make sure that we get the information that the other party says they don't have. So discovery is important. Lots of people do remain suspicious of each other and whether full disclosure has been made. In a separation agreement, there is a disclosure clause in it that says, before signing this agreement, I've made full and frank disclosure of all assets and interests. So there is that clause that parties are signing, that they've complied with that. But it is really important that we explain to clients you do need to make disclosure and that they fulfil their obligations.
Because I guess even the lawyer only knows what they know.
Absolutely.
Are told as well.
Absolutely. So. And people are at risk if they don't disclose their assets and they're discovered down the track. It's all going to be reopened in terms of the agreement. So,
and does it go back to square one if that's the case?
Yeah, so if it's a serious injustice, which is the test for setting aside a separation agreement, so it could be a serious injustice if you discover down the track someone's got $100,000 sitting in a foreign bank account somewhere, of which the spouse should have got half. We can't just set aside a small section of the agreement. The whole agreement goes.
Yeah.
So it is important that people comply.
Okay. So do you know any interesting case law that's quite well referred to in this area, or any interesting case or scenario or matter that you've handled? Just looking at the lessons for listeners rather than, the detail or the excitement of it. Not that, that's important. That's part of working with people. That's what makes it interesting. But, any kind of lessons out of matters or cases.
It is tricky in family law because every case is different. You see common threads coming through them, but every case has its own special facts. But probably the most interesting case I've been involved in is a really well-known decision. It's one of New Zealand's leading judgments called Scott and Williams.
Awesome.
So it's very rare for cases to get all the way to the Supreme Court in the family law context, because we have our family court and then we have our High Court.
Right, yeah.
Cases that go beyond that, the Court of Appeal or the Supreme Court, have to have some special public policy reason to get there, some public interest to have these judges hear the cases. So Scott and Williams deals with a really popular section of our legislation called economic disparity.
Okay.
So this is a case where we have assets that are divided 50-50, but once you've divided those assets in half, is there a significant disparity in the income and living standards of one spouse?
Right.
And if there is, then a judge can order compensation to be paid. So it's effectively getting more than 50% of the property pool. So that section came into effect in 2002, and it was new, and no one really knew how to apply it. Was it a 70-30 split, 60-40? How did it work? So the Supreme Court looked at this case in 2017, delivered its judgment at the end of the year. And, of course, we've got 5 judges sitting in the Supreme Court, all dealing with this section and all coming up with different results.
Okay.
So it's really, again, it's a murky area of law.
Yeah.
But for poor Miss Scott and Mr. Williams, that's 10 years of litigation in their lifetime.
Wow.
A lot of legal fees incurred, but dealing with a really important issue, particularly for people who have given up their career, stay at home, mum, given up their career.
Or dad these days.
Well, and that's why, in fact, one of the leading High Court cases on Section 15, when it first came into effect, was actually a male applying for an order.
Okay.
He was unsuccessful, but, it was interesting in who was having the benefit of the section.
Right.
But it's to deal with the classic scenario. Someone stays at home, looks after their children, gives up a career, and, in a lengthy relationship, they separate.
Right.
They're not earning that income,
of course,
anymore.
and they've lost all that kind of opportunity of career movement.
Yeah, so Scott and Williams is interesting in that we've got judges coming up with different ways we can compensate people and different formulas that can be used. So,
did it make it worse or did it make it...
With respect to our amazing, intelligent Supreme Court judges, it's made it murky.
Okay.
It's made it really murky. And so we've got different formulas being used to calculate the compensation by accountants, and we don't really have any consistency. So again, it's something the Law Commission's looking at the moment.
Still in that testing phase, really, for a piece of legislation.
Right. Yeah, so the Law Commission's come up with something called a family sharing arrangement, where they're just trying to simplify the law for couples who are separating, and their recommendation is you've been together for a relationship over 10 years, then basically you just get one spouse's income and then the others, and you should share it equally for 5 years.
Right.
That's the simple way of dealing with it.
Right.
But again, I think it's
tested in the courts.
Yeah, and it's difficult for clients to advise. So I think people are settling, which is a good thing, because
get on with your life.
That's right. It's a clean break, moving forward, closing the door on your marriage, making sure, particularly if you've got children, that you're keeping that amicable relationship with the parents and the children aren't exposed to any conflict. It's really vital.
Yeah, I was going to say, particularly for the children, they take it all on. So there's lots of reasons to try and have an amicable relationship with an ex-partner. Certainly avoiding stringing out court cases and the cost of that, both psychologically and financially.
Yeah, absolutely. Sense. It can be really expensive, the legal process for a lot of people. And so some people have to be engaged in it. They really do. If you've got cases where one partner simply will not negotiate or even respond about property division at all, well, you've got no choice. You've got the court there as the backstop to assist you and to ensure that people actually will come to the party.
I'd like to think most people tend to sit down and talk about it and try to come to an arrangement. So even if you come to an arrangement between yourselves, just sitting at the kitchen table, you've agreed and you're happy, you're both happy, it's taken a while, let's not say it's perfect, that's why you're splitting, but you've agreed, you still need to go and get independent advice in order to get that settlement signed off.
And I think that's a bit misunderstood by some people. They'll do a handwritten agreement between the two of them, they'll sign it, and they'll say, well, we've settled everything. Actually, it's not. So to be a binding agreement at law, it has to be in writing, signed, and independently advised by solicitors who certify the agreement. So you do need to get that agreement to a solicitor, get them to draw it up. Got to make sure you give them all the disclosure. So as I say, you've agreed between yourselves, someone's keeping the house. What value have you put on the house? So the solicitor needs to know all those details.
Yeah.
And then the independent lawyer needs to advise the other party and have it signed off.
Yeah, because I think that is usually where people get a little bit like, why do I need to get independent lawyers and why do we get more lawyers involved? But the reality is it's there to protect people, to make sure that there's not one party who's, might be in a position to influence the other, regardless of the situation.
Yeah, that's right. So you've got the lawyer acts for one party, so has their interests taken into account and can advise them whether or not it's a good deal or not a good deal.
They might still just say, well, even though it's not 50-50, we've still agreed it that way and we're okay. It's just about being clear on the position, as you said.
Yeah, and I've got a client at the moment negotiating the terms of her agreement, and they've come up with a deal. In my view, she's entitled to a lot more.
Right.
And it's just making sure that she understands that, because you do get people after a separation still quite emotional.
Very, yeah.
And I said to her, I don't want you to be coming to me this time next year where you're struggling and your ex-husband is continuing to earn a really significant income. He's able to take the kids to Fiji for the school holidays and he's having a good lifestyle, and you're thinking, why did I not get a better deal? So, as I said, it's really important.
Or your fair share, really.
Yeah, that's right.
Yeah.
That's right. So, yes, people can agree on what they like, but it's really important that they know what they're doing and they know what their rights are.
It's an emotional thing. People just think, oh, goodbye, I'm walking away. I don't care if I see any of it again. I've just got to get out. But then, 6-12 months later, it's like, oh, that was a really bad idea. I should have thought about that.
Yeah, and we often say to people, because often with a separation, you have one party who's the instigator of it, who's mentally they're much more prepared than the other person, who often gets the legal advice before they separate and then says to the other party, I'm leaving you. And they're devastated and they're distraught and they need counselling and they need that professional support around them. In those sorts of cases, we often say to people, well, you get your interim arrangements in place, But let's leave the substantive. There's no hurry. So you've got 3 years from the date of separation with your de factos to get your property sorted. And so there's no rush for you to get things signed up. So wait for the emotions to pass. Make sure that you're ready to get in and get it sorted.
Yeah, it's almost like having them be your advocate at that time when you're not thinking as clear as you could. Absolutely.
That's what I'm talking about.
Do you have any tips for listeners? It doesn't have to be legal.
Well, I guess the key one, I mentioned it earlier on, is a legal health check. And that's really important because a lot of the work I do, particularly in the context of estate litigation when people die, you have these family members feuding and at war with each other, particularly in cases where there's a second relationship and there's children who are wanting their share of property now. It doesn't take much to go along, see your lawyer, make sure you've got a will in place, make sure you get advice surrounding claims, get your powers of attorney in place. Do you need a relationship property agreement? Sit down with someone and just get your affairs in order because you want it to be peaceful. You don't want your family fighting.
Absolutely. Okay, that's a great tip of the day. Thank you very much. Well, that is it for our latest podcast. Thanks again to Stephanie Ambler for being on the show. Thanks so much, Stephanie.
Thank you for having me.
Oh, no problem. You're a wealth of information. So to our listeners, thanks for listening, and don't forget to subscribe and just to make sure you get the shows as they come out. Until next time, I'm Julia Stenson, and from us here, take care, have an awesome day. Kia pai tō rā.